Hello, everyone, and welcome. My name is Julie Byerly, and I have the honor of being the president of Geisinger College of Health Sciences and the dean of the medical school here at Geisinger. And it is our great pleasure to welcome you. One of the goals of our school in its founding was to improve community health and well-being. And through these educational sessions, which we do here monthly, but also broadcast and report about, thank you all for being here for that, help to boost community well-being through the sharing of knowledge relevant to health. So we're grateful to each of you for joining us today, and we're especially grateful to these guests, which Becky Slangen will introduce, who worked hard to get here through a lot of traffic, and we're so glad to have you. So I'll turn it over to Becky.
Good evening, everybody. I'm Becky Slangen, as Julie mentioned. I'm the Associate Dean for Academic Administration here at the Geisinger College of Health Sciences, and I'm going to introduce one of our three very special guests this evening, and that is Keith Hinkle Jr. Keith serves as the Assistant Director of the Office of Elder Justice in the Courts at the Administrative Office of the Pennsylvania Courts. In this role, he collaborates closely with the Advisory Council on Elder Justice and various AOPC divisions to advance initiatives addressing guardianship, elder abuse and neglect, and access to justice for older Pennsylvanians. Prior to joining the OEJC, he spent over 6 years as an information technology systems trainer for Pennsylvania's Common Pleas Courts. He holds a bachelor's degree in adult education and brings more than 17 years of experience in training and analytical work to his current position. Please join me in welcoming Keith.
Hey, thank you, everyone. And I want to give a special thanks to Geisinger for hosting these type of events locally as well as online so that more people can attend and hear the message. And these are such important messages for the community, for anyone that's getting older, that's aging, that may need assistance and kind of guidance on what they're really planned for. And that's what we really want to focus on here tonight. But first, I want to introduce the panel that is much more experienced than I am and much more important than I am. And I just want to do real brief because if I spent the whole time introducing them fully, we would be here for an hour just on introductions. First to my left is Secretary Kavulich. He was appointed, what year? I forget.
So I apologize. 2022.
2022, and has spent 25 years in human services and advocating for older adults. And previously he was the director of the Lackawanna Area Agency on Aging. Anything you would like to add, Secretary?
We're good.
All right. And both our panelists here are members of the Advisory Council on Elder Justice in the Courts as well. The second panelist over to the left is Judge Ruggiero. He is a Lackawanna Orphans Court judge in the Court of Common Pleas. I asked him for a couple bullet points to really highlight some things he wanted me to say during this presentation. He said the number one thing, he has a mom. So that's the experience that we're bringing here, which is wonderful. But in seriousness, he's been a judge since July of 2023. Prior to that, he was in private counsel for 26 years, brings a wealth of knowledge about court, about the orphans court, about proceedings in the courtroom, and really how to prepare for guardianship, alternatives to guardianship, and all the other topics we're going to be talking about here tonight. So our agenda for this session is going to be, first, we're going to have a message from the Department of Aging. So I'll pass that off to Secretary Kavulich here in a moment. I'm going to give a brief overview of our office, the Office of Elder Justice in the Courts. We're an office that falls under the Administrative Office of the Courts. We want to make sure that everyone knows that we're out there, that we are a resource center, that we can help you get in touch with the people that may be able to help in unique situations. We're going to do a brief overview of what guardianship is. We hear all the time in the news, in the media about guardianship. Oftentimes it's slanted to the negative, sometimes it's slanted to the positive, but just an overview about what that really is. What are some terminology that you should know about guardianship and how that really works? The bulk of our presentation is going to be on alternatives to guardianship and really how to plan to avoid guardianship, to make sure you have the right decision makers in place, that you have your paperwork in order, potentially through an attorney, or even just between family members, so that your wishes are honored as you age or become incapacitated really at any age, and making sure that you have that support network already in place. Before I pass it over to the Secretary, just to highlight why this is such an important topic in Pennsylvania. Pennsylvania is actually the 4th oldest state in the country. when we're looking at people over the age of 60. And that is how we define older adults in Pennsylvania is over the age of 60. I know the first time I said I told my mother I was working at the Office of Elder Justice and, oh, we help people over the age of 60 because they're older adults, she was ready to smack me. So that's not something that a lot of people want to accept, but it is the reality for every single one of us. We're all going to get older. We're all going to age. And we want to make sure we have resources in place and understand how to prepare for that day. So currently there's 25% of PA's population is age 60 or older. There's 2.8 million older adults in Pennsylvania, and this is expected to balloon over the next decade. We're looking at approximately 78 million people over the age of 65 compared to 76 million under the age of 18. That is the first time that the older population is going to exceed the younger population in this country. That's staggering, and it also shows why there's such a need for education and resources in the community. So without further ado, I want to pass it off to Secretary Kavulich.
All right. Good evening. Can you guys hear me? Everyone hear me? Good evening, everyone. Good evening to some of my friends that are out there in the audience. Always good to come home and see some friends and make sure that they're judging you extra hard when you're presenting. I apologize for being late. We did accommodate for Interstate 81, but as someone who is privileged enough to travel all over Pennsylvania and see everything that our beautiful state has to offer us, the worst traffic lies between Avoca and Scranton. I will tell you that with certainty. By far, it will ruin any plans that you have to get somewhere on time. So not to contradict my good friend Keith, but we are the 5th oldest state in the nation. I'm sorry. Okay. And this is how fast data changes. And this is why data is important. Because if we're not talking about data, we're not talking about the real numbers that drive our work, then we're not keeping up with current events and we're not keeping up with current times. So we are the 5th oldest state in the nation. There are 3.4 million older Pennsylvanians, okay? That means we're right now 1 in 4 people in Pennsylvania are over the age of 60, and that number is moving very rapidly. And we will be very soon 1 in 3 people over the age of 60. That is why Governor Shapiro had instructed the Department of Aging through executive order here in Scranton, in West Scranton, to go out and create a multi-sector plan, Aging Our Way Pennsylvania, for Pennsylvanians. It's not my plan. It's not the Department of Aging's plan. It's not the Court of Common Pleas plan. It's not the Administrative Office of Pennsylvania Courts or the Office of Elder Justice's plan. It's our plan as Pennsylvanians. 20,000 individuals, 20,000 caregivers, care recipients, older adults gave input to this plan all across Pennsylvania. That in less than a year's time, we have a 10-year multi-sector plan in Pennsylvania that covers over 29 state agencies and entities that has involved multiple stakeholders, groups, focus groups, and conversations all across PA that helps us through 167 tactics show what the next 10 years in Pennsylvania is going to be like for older adults. It's not some plan that we put on a shelf that we're proud of. It is a plan, as Governor Shapiro says, sits at the center of the table and that we reach to for answers and guidance, but it's a living plan and it has to change and evolve because older Pennsylvanians and their needs evolve so rapidly. Just like the statistics that we talked about just before. Things change that quickly in this world that we live in. So what does the Department of Aging even do? Well, the Department of Aging administers 52 area agencies on aging that provide services under the Older Americans Act. So that doesn't mean we work in the Medicaid space. That means we work in the older American space, which means anyone over the age of 60 benefits from services from the Department of Aging, regardless of income, et cetera. So that's what we do. And that means transportation. All the little blue buses you see driving through Scranton come through the Department of Aging. All our 455 senior centers all throughout the Commonwealth of Pennsylvania come through the Department of Aging. Home delivered meals, all in-home services, ombudsman services, guardianship services, and protective services all run through the area agencies on aging and the Department of Aging. And we're here today to focus on guardianship and why that's important, because our area agencies on aging are responsible for 24% of the guardianships in Pennsylvania. Now we know that because of the good information that Keith and Fran and Ralph and others get for us, and we keep track of that information and are able to then use that to really hone and shape our practice. So we, because of protective services, because of the Older Adult Protective Services Act, are involved in guardianships all across Pennsylvania. And it is why this administration, working with the gentleman here and the others on our committee, have made sure that guardianship is a absolute last resort for our area agencies on aging in Pennsylvania, for older adults in Pennsylvania. That we look to all least restrictive alternatives, which I know my colleagues will get into more, before we go and do one of the worst things. And I say that it's one of the worst things we can do. We take away someone's civil rights, because that's what guardianship is. We take away someone's civil rights. We take away their right to make decisions for themselves because they're incapacitated. And they've been deemed so by a medical professional that has the ability to do so. I don't get to make that decision. I never will be able to make that decision. But it does unfortunately happen. But we want to make sure that it only happens in the cases that are absolutely positively necessary. So it's the work that we do with them and others that really helps us shape those alternatives to guardianship. Work that makes sure that we're doing everything we can to keep track of those who have been already declared that they need guardianship, making sure that we go to court and review it, making sure they have robust counsel, making sure that our resources are used not in pursuit of guardianship, but in defense of guardianship, to make sure we're doing our part as the Department of Aging and the area agencies on aging to protect the rights of older Pennsylvanians, because we're there, that's what we're there for. We are the voice of older Pennsylvanians. We do that with the support of our teams. We do that with the support of the area agencies on aging. We do that with the support of the Pennsylvania Council on Aging and all of the regional councils that exist all across Pennsylvania. Pennsylvania Council on Aging, for all of you who don't know what that is a council that we have, a state council that's appointed by senators all throughout this Commonwealth to have older Pennsylvanians represented in the work that we do. They inform our work. They tell us what we're supposed to be doing. They tell us how we should be responding, and that's important because the voices of older Pennsylvanians should be in everything that we touch. And we want to make sure that they're heard and what they have told us informs our practice as we move forward. And so we use that council and then we use the regional councils that exist all across Pennsylvania to really make sure that we're making opportunities for voices to be heard, because that is essential, especially when we're talking about older adults. So I can do this all day. I can make this hour, I can make this hour all about the Department of Aging, but I really want to hone in and focus on, really what we're talking about today, and it's guardianship, something I feel very strongly about, protecting the rights of our older adults, but also making sure that we have good tools in Pennsylvania. We do work with our partners in Pennsylvania. One thing that we are proud of that we adopted in this county before any other county in Pennsylvania is IDA. IDA is the Interview for Decisional Abilities. And what that is, it's a tool that care managers go out into the field and use. It's an informed, evidence-based tool that helps them determine through a series of questions and interviews with an older person if a capacity evaluation is necessary. It doesn't replace a capacity evaluation. It doesn't do that medical piece, but it tells them this person's decision-making is diminished and we should seek more professional assistance with this person. Or it's saying this person's decision-making is sound, and as an older adult and as an older American, they still have the right to make bad decisions for themselves. It's a hard pill to swallow, but it's the truth. They still, unfortunately, will make bad decisions for themselves because they can, and it's their right. So again, I can do this all day. I love this. This is the work that makes me get up in the morning, makes me drive all the way from Harrisburg like a maniac. So I'm here by 5 o'clock and still failed. But I think now I have the honor of introducing my good friend Keith Hinkle, who has undersold himself and really is a tremendous asset to all of us and the Commonwealth. Keith's work is instrumental in not only assembling the first guardianship conference, assembling training throughout Pennsylvania, gathering data, gathering stakeholders, to the point where right now, as we speak, we have a delegation here in Harrisburg, interviewing all of us who sit on the council, who are working with the council about the work that's happening in Pennsylvania, because it is the national standard now. They're here as a bipartisan effort to review the work that's being done in Pennsylvania because it is so transformative. And it's thanks to work like Keith. And really, it is a huge credit to him and all that he does with his team to make sure that we in Pennsylvania are moving forward in this space the way we should be. So with that, I'll give you my friend Keith.
Thank you. And I think we can do that one more time for the secretary. And I speak from experience working with him for the past few years with the advisory council. The dedication is not just talking, about it and saying, we're going to do this, we're going to do that. It truly is accomplishing major accomplishments in Pennsylvania. The plan that they put out, the 10-year plan, is amazing. If you have not read that, please go and read that, understand what the vision is for Pennsylvania that's coming out of his office. It is an honor to work with him. I'm thrilled he's here. He said a lot of nice things, so I have to say nice things now. But it truly is an honor to work with him. And round of applause for everything you do. And ultimately, he's a local legend. We know that from this area. So next, I just want to talk a little bit about what the Office of Elder Justice in the courts does. As I mentioned at the very beginning, we are part of the Administrative Office of Pennsylvania Courts, meaning that we're a support office. We help the courts. We create education. We do a few other things, which I'm going to highlight here. We don't get involved with individual cases, but we can really help other agencies. And one of the areas that the Department of Aging has really helped us and really opened up so many doors is that collaboration to do events like this, to build programs that affect not just the courts, but the public, guardians, adult protective services, and a slew of others. Some of the highlights of what we really focus on, education is number one. One of the biggest things we hear from guardians or people that are getting older that are starting to look for help and look for resources, I don't know where to start. Or a guardian gets appointed, they're doing it to help a loved one. What did I get myself into? That's where our office comes in through education. There's handouts up front on how you can get onto our free online education. There's online videos that you can watch for free. There's a handbook that you can order a paper copy. I brought some with here as well. But we do, in our role, not only do we educate the public, attorneys, guardians, the courts, etc., we also assist the courts with guardianship and access to justice issues. So as we see emerging trends that we might see across cases, across courts, across the nation, we can go back and assist the courts to really make sure they have all the tools to make sure if an older adult needs something in court, they have the resources to help them. If there's something with guardianship, there's new legislation, we can make sure there's education out there for that as well. We also assist the courts through monitoring guardianship cases. Every court monitors their own cases. They review the annual reports that are required to be filed by every single guardian that's appointed. We help standardize that approach through training, through materials, through visits to the courts to make sure that these vulnerable individuals in our society have the court looking at them. They have eyes on those reports. They have eyes on their well-being, their financial situation, to make sure they're not being exploited, that they're not being abused. And we want to make sure every county has the assistance they need to meet those requirements and expectations. And we do maintain a website, a resource website. I can give you that web address, and it's in our book. It's awful. I will be 100% honest. It's a court website, so there's a lot of letters and numbers to get to our website. It's much easier. Just Google Office of Elder Justice in the Courts. You'll get to our main page. Through there, you can get resources for guardianship, for legal assistance, information on alternatives to guardianship, and all of the educational resources we offer, including videos, the handbook, etc., which are pictured here on the screen. This handbook really was the first of its kind in our state that really standardized the approach, gave terminology. This was handled through our office, and it really takes you through. If you're someone that's possibly going to become a guardian, you're already a guardian, this is kind of your life-saving guide to make sure you know when you have to go back to court, what you're allowed to do, what you can't do, etc. There's also 14 videos, again, all free to watch. They're about 5 minutes each, that walk you through what it means to be a guardian, again, the terminology. And there's two distinct roles. You're either the guardian of the person for healthcare, guardian of the estate for the finances. Those videos walk you through what really both of those roles truly mean and how to perfect your role as a guardian. So speaking of that, let's talk a little bit high level about guardianship. We could be here for 2-3 hours. We run trainings for guardians that are about an hour and a half, 2 hours each, for one for the person, one for the estate. So we can't cover all this in a half an hour to an hour, but we wanted to really highlight some of the key terminology. And I'm going to ask Judge Ruggiero to join me here as we talk about a few of these different points. So big picture, what is guardianship? It's for an adult who is unable to receive or understand information or communicate their decisions. We heard from the secretary earlier, it's not about making bad decisions. We all grew up. I see some younger students in the crowd. We've all made bad decisions. We're allowed to make bad decisions. When we need a guardian, It's when we're making a decision because we don't understand what's in front of us. We don't understand the information that's coming in, and we're unable to make a decision without somebody's help, or we're just not able to make that decision at all because we're not comprehending what the impact would be. We're not comprehending how this would affect my life. That's when we're getting to the stage of needing a guardian. It's not just because, oh, I want to spend $1,000 on lottery tickets because I have a little extra money. That might be seen as a bad decision. That doesn't mean you need a guardian. These are more serious health-related, financial-related decisions that you really don't understand what's happening. The person's unable to manage their finances. There a lot of times when someone is in need of a guardian, they're considered an incapacitated person, they're a much higher risk for scams that you and I that are normal making decisions, we feel comfortable making decisions, would never fall for the scam where someone from Nigeria is emailing saying, hey, you got $1 million, just give me your social security number. Those kind of scams, it's a lot more vulnerable for someone that doesn't understand how to make that decision and understand that information that's coming in. So those are some examples of really where guardianship is going to come in. And the terminology that's used in Pennsylvania is an incapacitated person. A lot of more modern terminology is a person with a guardian trying to be a little more centered on the individual. But in statute, in our rules, we refer to it as incapacitated person, and you're going to hear that throughout our presentation. Judge, is there anything you'd like to add about guardianship from your perspective?
I would. Thank you, Keith. And let me first thank Geisinger and all of you for taking time out and being here this evening. It's only through these educational forums, really, that we can spread the word and we can share ideas, and that's how we move forward. This is an important topic. And I always start really by saying I'm new to the guardianship world. For 26 years, I was a trial litigator, and I did everything from summary traffic offenses to murder cases. What I didn't do was guardianships and anything emanating really out of orphans court. So it's been a very wonderful experience for me over the past 2 years, but through my association and relationships with Secretary Kovolich and Keith and the folks on the Advisory Council and the Office of Elderly Justice, I've really come to understand how important this topic area is. And I've said to these folks, as well as to our president judge in our county, I'm committed, and I'll stay on this court for the long haul, because it takes that type of dedication and it takes that type of time so that you can foster these programs and you can create a court and a program that serves, really one of the most vulnerable populations in our society, the elderly population. But Keith, Secretary Kovolich said something, that was very poignant. He said, the decision to make, or the decision about granting a guardianship, is probably the single most significant decision. They're all significant, but it's really the only decision in which we make as judges that completely eviscerates, to an extent, someone's civil rights. Even those in criminal cases in which we have to incarcerate them because of something they did, even in those instances, yes, we're restricting their freedom and we're restricting their access, but they still have the ability to make many of their own decisions and do much of the thinking for themselves. So it really is the only area in the law, to Secretary Kovolich's point, where we really do take away one's civil rights. We understand, and there's a process when we have to do that, but I never forget that. And I want to start by simply just building on what Keith had said. And I think as we go forward in understanding the philosophy and policy behind why we should look for lesser restrictive alternatives, you need and should understand the purpose of the Guardianship Act, which is found at Title 55. And this is really Chapter 55. And this is what it is. And I apologize for reading, but it's stated here so beautifully that I just think it's worth recapturing. Recognizing that every individual has unique needs and differing abilities, it is the purpose of this act to promote the general welfare of all citizens by establishing a system which permits incapacitated persons to participate as fully as possible in all decisions which affect them which assists these persons in meeting the essential requirements for their physical health and safety, protecting their rights, managing their financial resources, and developing or regaining their abilities to the maximum extent possible, and which accomplishes these objectives through the use of the least restrictive alternatives, and recognizing further that when guardianship services are necessary, it is important to facilitate the finding of suitable individuals or entities willing to serve as guardians. So not only is the philosophy behind finding lesser restrictive alternatives included within the statute, the law requires it. And the reason simply is that we want to maintain as much autonomy to the individual as we can before we have to make a decision relative to a guardianship of their person, which Keith has indicated in most instances will go towards the medical decisions, and then a guardianship or a guardianship of the estate, which oftentimes will go to the financial resources. So I think the purpose and philosophy behind the statute and understanding that is helpful as we move forward today and talking about the least restrictive alternatives.
Thank you, Judge.
Keith, thank you.
So a couple other key terms just to highlight as we're starting to talk about alternatives to guardianship in the rest of the presentation. There is emergency guardianship. Sometimes there's someone that's a younger adult, because what we're talking about here, because our scope of the office, we do look at adults over the age of 60, the Department of Aging over the age of 60, but guardianships affects any adult over the age of 18 that's deemed to be incapacitated by a doctor and then ultimately by the court and in need of a guardian. So what we're talking about here can really apply to anyone of any age. And emergency guardianships are really a prime example of that. If anyone of any age gets into, for example, a car accident, they're not able to make decisions, they've had a traumatic brain injury, they're going to need a guardian appointed, and there's going to be decisions that need to be made now, not in 30 days after a hearing or 90 days after a hearing, whenever that's able to take place. They need someone in place to make those decisions immediately. So there can be an emergency guardian that's appointed. That's a very short window. They're going to have those emergency powers for up to 30 days. And then a permanent guardian potentially could be appointed in that situation. There's also limited and plenary guardian. Just because someone has a guardian doesn't mean, as both the panelists mentioned, that you lose all of your rights. You do lose your autonomy, a lot of your autonomy when a guardian is appointed. That's why we want to save that until it's absolutely necessary. But there are situations where a person could still make some decisions for themselves, but they need a guardian to make other decisions that, again, they just don't really comprehend the impact of what they're doing. So we'll see sometimes where a guardian will be appointed to help get on a limited basis, to help get set up with benefits, to help potentially sell a home, to transition into a new living facility, but they can still make decisions about their health care. They're just not able to make decisions that relate to their financial well-being on a grander scale like that. They could still pay their bills monthly. They're fine with that. It's those big decisions they need a guardian to step in and help that. So that's an area that we are seeing more and more in Pennsylvania, identifying where a person can keep that autonomy and that decision-making ability, but a guardian can step in other areas. And ultimately, these cases are all monitored by the court. As I mentioned earlier, it starts with a petition that's filed by someone that sees that individual struggling, that sees them not being able to make those decisions themselves. This could come from a family member. It could come from different agencies. It could come from the hospital. It starts the process, but they don't get to make that decision. That ultimately is going to be decided by medical evaluation, mental health evaluations, and ultimately the judge to determine if this person truly does need a guardian. And as they alluded to earlier, there has been new legislation that passed, Act 61 of 2023, that went into effect in the middle of 2024, that put an incredibly strong emphasis on alternatives to guardianship. In the petition, when they're petitioning for the court to grant a guardian, they have to explain to the court why these alternatives are not going to work. It's not simply, I want a guardian, this is what I want, stamp this, move on. They have to justify it. It's not something that's going to go quick. They have to justify why this person can't make decisions themselves. Also, because of that legislation, if someone is going and possibly in need of a guardian, we call them an alleged incapacitated person, they're now going to have their own attorney. They must have their own attorney in those proceedings that represent their wishes. That way, before, it was really based on the need. The judge always had the ability to appoint an attorney to represent an alleged incapacitated person or an incapacitated person at any time. Now it's required. So if that person can't afford their own attorney, the court will appoint one for them, just again, to make sure that we're looking at guardianship as the last result. There's got to be pre-hearing meetings. There's evaluations. This is not something that's done quickly. And ultimately, a guardianship hearing will be held. All the facts will be laid out. The attorneys will discuss. And then ultimately, the judge makes that decision if a guardian is actually needed. As I mentioned, guardian of the person, to keep this quick, the responsibilities, high-level responsibilities of a guardian of a person is on the screen. These are really your healthcare decision-making. This is maintaining a safe living environment. If they're able to live independently, great. But if it comes to a point where they need to transition into a long-term care home, a group home, if they're a younger adult, a nursing home, that's the responsibility of the guardian of the person to make sure that process is taken care of, managing prescriptions, doctor visits. And we expect our guardians to visit the person that they're a guardian of. This is not something they're just filling out paperwork once a year and sending it to the court. The court expects them to visit, ideally at least monthly, if not more, to make sure this person is okay. If you're responsible as a guardian for their health and well-being and you're never seeing them, how do you know they're okay? So this is an expectation of being a guardian. For the guardian of the estate, this is the finance side, paying bills, making sure taxes are paid, making financial decisions. If a house has to be sold because they're moving, that's going to be their responsibility. But there are areas, again, such as selling a house, where the court has to be involved to make sure that they're getting the appropriate money for those larger assets. There's still decisions that even as a guardian, they don't have full autonomy and full authority to make. The court needs to pre-approve some decisions. Again, we don't have time to get into every little detail. They're in the handbook of what is required that you have to go back to court. But the guardians do have a lot of power, but there are things that the court still needs to monitor, and they monitor every single year through annual reports, through review hearings, and other communication with that guardian. So without further ado, we're going to focus for the rest of this presentation on alternatives to guardianship. So how do we prepare to avoid guardianship? What methods are out there to make sure that we don't have to go get a guardian, that we have everything set up? And I'm going to pass that over to Judge Ruggiero to take over and give me a little bit of a break from speaking.
Sure.
So
Thank you.
thank you, Judge.
Which button do I hit here? The top.
This one. Nope, to the right.
Okay, very good.
Mhm.
Thank you. All right, good evening, everyone, again. Let me pick up, if I can, where Keith left off. So this Act 61, which was implemented in December of 2023 and took effect in June of 2024, was probably the most monumental change to the Guardianship Act in the last 20 or 30 years, if not longer. And it did a number of things. The first thing it did is it required that any alleged incapacitated person now be appointed counsel. You might think, well, that seems pretty common sense, and that should occur in every case. And I will tell you, and a big part of it is because of the folks that we have here in Lackawanna County. That's something that we've been doing forever, as far back as I can recall. And as I talk to the folks that have been there for many years longer than I have and doing the guardianships, we've been doing that forever, because that's critical. The second thing Act 61 did is it really put an onus on counsel appointed for the alleged incapacitated person to be an advocate. Their role is to not just do what the alleged incapacitated person desires or what the family desires, but their role is to advocate. And oftentimes they'll be advocating, and in that role, their advocacy on behalf of the alleged incapacitated person may be in conflict with either what the family is desiring, the individual or folks who are petitioning, or it may be in conflict to what the court determines or feels may be in the best interest of that individual. So in those instances, we have the ability to appoint a guardian ad litem if we needed to ensure that that alleged incapacitated person is represented as fully as possible. The other thing it did is it established the guardianship tracking system, and that's very critical before we get into the alternatives, because for the first time, we now have a statewide tracking system where we can, or the Office of Elder Justice can, monitor the guardianships that are being filed, how those guardianships are being handled, the reporting that goes with those guardianships, which is not for tonight, but there's a number of reporting requirements that have to occur. So all of these changes under Act 61 really have been monumental. And then that leads us in to the alternatives to guardianship. When a petition is filed before the court, the first thing we do, and when we get to that courtroom, there's a 5-step analysis that I go through as a judge. The first part of the analysis is I have to do a capacity evaluation. Now, I'm not doing the evaluation, but I have to make an evaluation based on the evidence to determine whether or not the alleged incapacitated person suffers from either some partial or total incapacity, which precludes or prevents them from making sound decisions, whether it's regarding their medical decisions, whether it's regarding their financial decisions. And how does that occur? Well, that occurs through the evidence, oftentimes through an expert report, medical testimony, and the like. And we hear that evidence, and I make that determination. If I make a determination at that point that there's no partial or total incapacity, it's over. The case is over as far as the filing of that petition goes. Now, that doesn't mean we just say, okay, you walk out the door. If we can assist them in some regard, helping them find other alternatives to the petition, even though we're not doing it as part of the analysis in the petition, we try to do that because we understand folks are coming before the court because there's a need. The second part of that analysis, before I do anything else, if I determine that there's a partial or total incapacity, before I do anything else, the law requires I go right into looking at alternatives to guardianship. Before I even go to determining whether there should be a plenary guardian or a limited guardian, the law wants me to look at alternatives to guardianship and to determine if any of those exist. Why? Because of that policy that I read to you when we started, which the policy of the act, again, is our goal is not to try to find a guardianship. It's quite frankly to try to find a lesser restrictive alternative to guardianship, to maintain or to allow the alleged incapacitated person to maintain as much of their own individual autonomy as they can. So that's the analysis. So how do we do that? Well, in Lackawanna County, we have an unbelievable system in place, thanks to Ralph and Fran Kovaleski, Ralph Marino and Fran Pantuso, and our Register of Wills, Fran Kovaleski, as well as to Secretary Kovolich. Because those of you that don't know, before he became and was appointed the Secretary for the entire Commonwealth, we were fortunate to have him as our Director of Area Agency on Aging. Jason, for how many years?
6.
For 6 years. And I had the distinct pleasure of working with him at least for 4 of those when I was the county solicitor. And that's where I knew Jason for many years, but I really got to see the professionalism that he exudes day in and day out. And it really was no mistake that the governor chose Jason to be the Secretary of Aging. So when we look at alternatives to guardianship, we start going through this analysis. First thing I do, of course, I'm looking at the petition because what does Act 61 now do? It requires the attorneys filing the petitions to put in the petitions what steps they've undertaken to try to figure out or determine if there are any lesser restrictive alternatives. So we go through that analysis. We talk to counsel. I talk to the folks from the Register of Wills. One of the other unique things we do here in Lackawanna County as well to try to address alternatives to guardianship is I require the petitioning party to also serve our local Office of Behavioral Health, Intellectual Disabilities, and Early Intervention, because that office, not so much in the context of guardianships, but that's what they do oftentimes. They're focusing on capacity and individuals' capacity. So even though they may not have this individual already, sometimes they do. If they don't, they're right from the beginning helping us determine if there are any lesser restrictive alternatives to guardianship. So we go through this entire process, step 2 of our analysis in court, to determine if there are any alternatives. And why do we do that? And why should alternatives be considered? And if you look at the screen here, these are just some of the reasons. First, the emotional impact and loss of autonomy. We can talk about that forever. The first 10 amendments, right, to our Constitution are called the Bill of Rights. There are individual rights. So they're there for a reason. And in the stroke of a pen with the right evidence, those rights can be stripped away legally and properly in the right circumstance. But before we get to that point, we want to make sure that we've exhausted all of the potential alternatives to guardianship. Oftentimes, we find out that the petitioner's primary concern is making healthcare decisions. And so in that regard, there's a number of different things we can do. We'll talk about as we go forward, whether there's been any advanced directives, any planning in place, whether there's any power of attorneys, durable power of attorneys, healthcare proxies, living wills. We go through that analysis to determine that. And then sometimes sometimes there's none of those. And of course, once capacity is compromised, whether it's a total or a partial incapacity, then you can't look at those alternatives because they don't have the capacity to enter into those documents. So when we start looking at it a little further, we'll often sometimes find out, as Keith pointed out, maybe it is just an issue relative to their healthcare decision making. So now we're just looking at a guardianship of the person as opposed perhaps to a guardianship of the estate. Maybe, for example, there isn't much to the estate, or there is no estate, or maybe they're just getting Social Security. So now we can deal with the guardianship of the person and the medical decision, but relative to the guardianship of the estate, maybe they just need a Social Security rep payee. Maybe they don't need the guardianship of the estate. So that's the analysis we go through to determine. Next line here. Finances often are managed by Social Security rep payees or special needs trusts. So if a special needs trust was established or is established, or if it's a situation where there's no additional outside income or there's not any assets to the estate, you can consider either a Social Security rep payee or a special needs trust. There's no annual reports to review from cases in which a less restrictive alternative is recognized. One of the difficulties oftentimes with guardianships is, and we have, they're kind of broken down between professional guardianships, which under the Act is those that handle 3 or more guardianships. And then there's those that we're probably most familiar with, Frank's mom is having some issues. Frank thinks that she needs a guardianship. Frank contacts a lawyer, gets some advice. We go in, we're filing for the guardianship. I'm just seeking to be a guardianship for my mom to help her out. But I don't know what that guardianship entails. I don't know what my obligations and duties are, but there's a lot, and there needs to be, because the person who's now responsible for the alleged incapacitated person, or at that point, incapacitated person, needs to be accountable, but also needs to understand what their obligations and duties are. So one of the biggest is the annual reports and the reporting itself. So there's initial, I believe 30-day reporting it is, right after a person is appointed, a guardianship, I believe, of the person. And then there are annual reports, which are due each year thereafter. So a part of the change in Act 61 with our guardianship tracking review system is to ensure that each county can properly track those guardianships and the filing of those reports so that we can ensure the reports are being reviewed. And then there's report reviewers so that that incapacitated person has these reports filed and another set of eyes and experienced eyes looking at these reports to ensure that everything that is properly reported is reported. If an alternative is selected, none of that reporting is required. So that's a benefit. And then, as Keith pointed out, sometimes the need may just be temporary for a guardian. Sometimes it's just about applying for medical assistance or Medicaid. And in that regard, we need to appoint a guardian to do that because they need to have the insurance. But we know once that application is made and approved, they don't need a guardian anymore after that. So what we'll do is we'll appoint the limited guardian only for that purpose. And in that instance, we delineate that in a court order, which means they have the capacity to make every other decision in their life relating to their lives. And then we bring them back, or, we indicate in the order in some way, shape, or form that at the conclusion of the guardian's limited duties, that guardianship would terminate. and then that would end that. So it's really, really important to look at these alternatives to guardianship, both from the perspective of the alleged incapacitated person, but also from the perspective of the family and the individuals who are going to care for them. All right, let's talk briefly about some of the alternatives to guardianship. We probably could take each one of these and hold an hour class on them. And this is not an exhaustive list, but it's a very good list, okay? So some of the less restrictive alternatives include, and you've heard some of these, I'm sure, or most, or if not all of them, advanced directives such as durable power of attorney or trusts, living wills, healthcare powers of attorney, healthcare representatives, financial powers of attorney, trusts, including special needs trusts, representative payees for individuals receiving Social Security benefits. That was the Social Security rep payee we just briefly spoke about. Pennsylvania Achieving a Better Life Experience account, and mental health advance directives. All right, let's go through each one individually. And again, this is not to give you an all in-depth discussion on all the intricacies of each of these, but it is to introduce them to you so that you can begin thinking about them and know of them, so that when you're dealing with these situations, because you cannot deal with guardianship, cannot deal with it without doing this analysis of going through the alternatives. And if we can do that, certainly from the court perspective, as we're required to do it, and then we can bring that out into the community perspective, to the medical community, and to those, the nursing home community, and to all of those that are really dealing with and handling our elder population on the front lines. A lot of the guardian, or many of the guardianships, I think we'll find out, either may not need to be filed or can be somewhat curtailed, as the example we gave you, limited, or you'll find that maybe there's a hybrid of sort that you can do some type of limited, or even a plenary on one side, but maybe you have a less restrictive alternative on the other. So a durable financial power of attorney is a very common legal document. I'm presuming we've all heard of it. You see these terms, durable and springing. So a durable financial power of attorney, that's where the principal or grantor authorizes their agent to make financial, legal, and/or business decisions on behalf of the principal. And it says maybe springing. So all that means is a durable financial power of attorney. Durable means that it's effective immediately upon execution. Springing means that it's effective upon the occurrence of a specific event. So you can set up a financial power of attorney where the springing event is your incapacity. So you plan not for your incapacity, but you plan just like you would plan for the future when you're doing your estate planning and everything else. Because at that point, you're able to make the decisions, obviously, for yourself and entering into the power of attorney, but you're really also able to make the decisions for yourself going forward if, unfortunately, you find yourself in a situation where capacity fails you, and you're talking about a guardianship. So, I would tell everyone all the time when I was in private practice, I didn't do a lot of estate planning, but I would tell folks, your last will and testament, your living will, and your power of attorney, those are forms of advanced directives, which we'll talk about. But those are also lesser restrictive alternatives. But the thing with the power of attorney, just like many of the other legal documents, is they have to be effectuated and executed prior to any loss of incapacity. But and a lot of people misunderstand this, even if you have these documents, even with the loss of incapacity, these documents can still direct and dictate what is to occur going forward. The key is, of course, did you have capacity when you made them? That's why we call them advanced directives. The old adage, what did they say? You don't fail to plan, you don't plan to fail, you fail to plan. That's really what this is about. It's about estate planning. Not that this seminar is, but a lot of this is about planning for your future. The next type of least restrictive alternative is a simple joint bank account. Created with a trusted family member or a friend, can allow a person to maintain financial autonomy while having a trusted person help manage the account and budgeting, helps monitor fraud. There are risks though. Joint owner has full access to your funds. So that could be a problem. That's why, of course, easier said than done. Sometimes you want to choose that person that you trust the most, or maybe not the most, but that you trust implicitly with your finances. And that is one form of alternative, because if it's a joint account, they do have the same right to the funds that the incapacitated person does, but they can withdraw those funds and use those to make the payments or do whatever they need to do on behalf of the alleged incapacitated or incapacitated person without the guardianship. But you got to keep note of the risk there. So oftentimes you'll see that, I think, where I've seen it in the short time I've been doing it is instances like, for example, where you maybe have a parent and you have a child who's over the age of 18 and there's an incapacity and something like that. But it does not exclude those who are non-family members. So if you have that person that you trust and you're comfortable with, that is one potential least restrictive alternative to consider. Another is what we've already mentioned, a Social Security representative payee. So that's just simply where someone's receiving Social Security income, whether it be disability, whether it be retirement, whether it be SSI, whatever it is. And there's a rep payee. And that rep payee receives the funds on behalf of the individual by Social Security. And obviously, they are to manage those funds and use those funds for the benefit of the Social Security recipient. So the rep payee manages Social Security or SSI payments. The funds must be used to benefit the recipient: food, clothing, housing, medical care, etc. Everything there that we would address in a guardianship of the person, which would deal with all the finances, guardianship of the person, which would deal with the medical care, and a guardianship of the estate, which would deal with the financials and the housing and all of that. So Social Security rep payees, we see they're quite prevalent, and oftentimes they are used to avoid a guardianship of the person. But the thing there is there really has to be no other really source of income coming in, because if there is another source of income, even though you can have a Social Security rep payee for the Social Security, you'd have to deal with the other form of income that's coming in. Another least restrictive alternative is known as a Veterans Administration fiduciary. Those are veterans who are unable to manage their financial affairs. They can nominate a person they trust to serve as a fiduciary. The VA investigates before approving and appointing a fiduciary. I will say, I have a little bit of experience with this. The VA does do a good job. It's not as though you just fill out a form, send it in, and I want John Doe or Jane Doe to be my Veterans Administration fiduciary. No, there's a whole set of background checks and things that go into that by the VA, which is very helpful. But it's only used, obviously, for those who are entitled to veterans benefits, so we don't hear about it very often. But if you do know a veteran or someone who is in that situation who is a veteran, that is a very good alternative to guardianship to consider. Let's talk a little bit about advanced directives for healthcare decisions. So this is what we talked about. We just mentioned the power of attorney a little bit. So it's very similar, except the power of attorney is really just dealing with the financials. Now we're going to talk about the advanced directives for healthcare decisions. What are they? What is it? It's a legal document typically, which provides instructions for medical care, but it's created just like the power of attorney prior to any incapacity. That's why it's called an advanced directive. Living will. It's a legal document. Living wills are documents which simply inform doctors about patients' preferred treatment options. You fill them out. They're simply, the ones I used to do were 2 pages, and they were pretty detailed down to organ donation and which organs you desired to be donated. They can be that specific, but they're very, very important And, I'm not going to put any of the medical community certainly on the spot, but I think the medical community would agree that they'd rather have a living will than not have a living will in a situation where it's unclear about what the patient's preferred treatment options are moving forward. And I would encourage everyone, if you don't have one, and it matters not your age, because, you can leave here tonight and God forbid something can happen, but they're very important. So living wills are very important alternatives to guardianship, because oftentimes medical decisions have to be made. That's how the guardianship comes into me, usually as a guardianship of the person because of a medical decision. And Keith mentioned it. Oftentimes it's coming in as an emergency guardianship, which means I have to appoint a temporary guardian immediately to start making those decisions. And then I got to have a hearing within 72 hours. But the treatment that alleged incapacitated person needs is immediate. They can't wait 3 days for that treatment. So, we make the best decisions we can based on the filing of the petition and the information that's in there. But if there were a living will, and you find out oftentimes there's no living will, but if there was a living will, oftentimes I may not even see that petition, because the living will would direct what the patient's preferred treatment options were. So there's no guessing by the medical staff, and there's no guessing by the family. Even if the family, this happens, has one opinion, but you have the living will that has the other, the living will controls. And so at the end of the day, that's an advance directive, very important form of alternative. But you can see how you have the ability to have decision-making. You have the ability to have decision-making relative to these issues before capacity becomes an issue, if you plan properly. Advanced directives. Another form of advanced directive is a healthcare power of attorney. And so what does this do? This grants an agent power to make healthcare decisions on behalf of the person. Power of attorney can specify the spectrum of care, including routine care, end-of-life care, et cetera. Okay, so maybe, someone has a healthcare power of attorney and they have a living will, but doesn't mean that every document catches everything. So the living will would tell the medical staff, this is how the incapacitated person, this is their preferred course of treatment. But maybe there's decisions that have to be made that are not contemplated in that living will. Well, that's where the healthcare power of attorney would come in, where the medical staff could talk to that person that's been appointed by you, which presumably you would have talked to that person as you're going through that process, so they understand what your wishes are, which are further memorialized in the healthcare power of attorney. And as that's delineated, again, another opportunity for you to have decision-making relative to an issue where if capacity becomes an issue down the road, you won't have that ability. And then the court has to make that decision by the appointment of guardians or a guardian on your behalf. The next type of alternative, least restrictive alternative, physician order for life-sustaining treatment. It's a document which is typically created by a doctor or a medical provider. It's signed by the doctor and the patient, and it establishes a patient's preference for end-of-life care. And so it's another advanced directive, another opportunity to engage in decision-making, and it's all about planning for your future, but it's all about allowing you, if you ever find yourself in that situation, to have a alternative to guardianship considered, because you've already considered and decided it, without the necessity of a guardian, which is exactly what I as a judge want to see happen, which is exactly what the Secretary and the Office of Elder Justice and the legislature and what Act 61 is designed to do. And that's why it's important. And that's why in the analysis as a judge, I don't want to overstate that, but I don't want to understate it. If I determine someone has a capacity, they don't even want me to look at what type of guardianship. They want me to now first figure out if there's a way to deal with that capacity short of a guardianship. And if I can't, only then go to step 3, which is to determine whether it's a plenary guardian or a limited guardian. Okay. mental health advanced directives and power of attorneys. Provide, some of this we covered, but provide specific guidance on a person's preferred treatment, medication, and providers during a mental health crisis. So, you know, you may have a diagnosis early in life, whatever that may be. And maybe, you know, maybe the prognosis going forward is that, you know, that condition may exacerbate and worsen down the road. And if you know that, and that may affect your capacity, then here's a wonderful example of an alternative to guardianship that you'd want to do, and we would encourage folks to do if they can, because of course you have to have the capacity, again, with all of these to be able to enter into them. But if you do so, obviously it provides the court, and if you do these, chances are you're not even in a courtroom talking about a guardianship, because the alternatives are going to be addressed otherwise. If the medical staff and the family know what your wishes are relative to your treatment and your medical condition, then they don't have any questions. They don't have to come to the court and get a guardian to help them answer those questions. Healthcare representative. They're healthcare agents. It's under the Healthcare Agents and Representatives Act. And what this does, this is unique, but there's a priority order, okay, of really who are the decision makers. There's no court order needed, but you can create a document, but under the act, it specifically lists the priority of order. So the first is spouse and any adult children of the person. The second is other adult children, children of the spouse. Third would be the incapacitated person's parents. Next, adult siblings, adult grandchildren, and then other adults. I haven't seen this. I don't know, Secretary or Keith, if you can speak to any of that. Is that something that?
I think that I have not seen it in
Okay.
in our space. But I think that also speaks to the intellectual disability community and work that happens with guardianships under the age of 60.
Right, okay, excellent. All right. And supported decision-making. And this is a process, there's really no court order, but it's a plan to have your people together, whoever that is, and to have them connected, as you can see here, with your financial folks, your health and wellness folks, career and education, so on and so forth, so that there is supportive decision-making as a collaborative effort if you get into a situation or you find yourself in a situation where capacity is being questioned or at issue. And that brings us to planning for the future. Let me just turn to Secretary and Keith, before I ask Keith to come and back up, is there anything either of you would like to add to the alternatives? Secretary Kovowicz really has been at the forefront of a lot of this. And I say this respectfully, he's forgotten more about it than probably, at least I'll speak for myself, I'll ever learn. But as a resource, anything, Secretary, you want to add?
No, I just want to real quickly say, you know, especially for the students that are with us, you know, we have to remember, you know, there's a person that we're talking about. You know, we talk about the reasons, we talk about the process, we talk about payments, unfortunately, in our world. You see guardianship decisions being made at hospitals because they want to see someone transition to a nursing home and make sure that individual's nursing home bed is being paid for and covered before they move. We talk about all these things in our system and we forget sometimes there's a person in the bed, there's a person at the center of the conversation. And as we go forward and do this work, we can never lose sight of the fact that we're talking about a human, we're talking about a person with rights, and that we always have to put that first and foremost with whatever decision we're making. I find it incredibly one of the greatest challenges any human will have to face is what Judge Ruggiero has to face when he looks at one of these cases. It is a monumental decision. It weighs on a person. I respect the process in which they have to go to, but as we are practitioners, and I know we have a wonderful certified guardian in the audience tonight. I know I have other colleagues who've worked in this space with me in the audience tonight. We have to keep this in mind. There's a person at the center of these conversations.
I think just to add, well said. I mean, that's tough to follow, of course. But just really to add to that, it's so many of these alternatives you're probably already doing and not even realizing it. When you go to a doctor, if you're married, you have a spouse, and they put, who can we contact about medical information? That's really a type of identifying a healthcare representative. Who else is going to be able to help make those decisions? Who else can counsel you on those decisions? Supported decision making. Any of you in here bought a car that you called your uncle that's a mechanic? That's supported decision making. They can be boiled down to that simple of an analogy, but it's something that we just don't think about for when we age. And as the secretary mentioned, these are people, and we have to remember that. And we want to make sure that they keep their autonomy, they keep their decision-making ability as long as they possibly can. It may come to a time where guardianship is the right answer, and that's not a bad thing as long as we wait until the very end to do it. Guardians have a professional guardians, family lay guardians, like the family members that are guardians, have such a tough job, but it's such an important job. We want to make sure that role is reserved for only the people that need it most. So, Judge, you want me to take
Yeah,
the next
please do.
couple here?
Yes, you got it.
Thank you, Judge.
Thank you.
Judge.
And I think you can hear from the last half an hour or so talking about alternatives, while Judge Ruggiero says he's new to this, what a wealth of information. That was probably the best crash course in alternatives you're going to hear. Like he said, we can spend a lot of time on every single one of those topics. And that's something that if Geisinger has us back, we may take more of an in-depth approach on some of those different topics. But real quick, just to highlight what we talked about and really how this ties into planning for the future. As I mentioned, the universal truth is we're all going to age. We're all going to get older. Some of us, when we're in our 20s, our 30s, we're invincible. We're never going to have to worry about this, but anything can change. Unfortunately, car accidents happen. Incapacity can happen really at any age and at any time. So when you're preparing, make sure you're identifying trusted family members or friends that can help you make those decisions. Like the example I gave earlier, you all already have that. Talk to your family, talk to your friends that as you age, who's going to help you make those important healthcare and financial decisions. Talk to an attorney. There are resources on our website. If the boundary or the barrier for you getting these kind of alternatives set up, this preparation set up, is financial, our website and other websites through the Pennsylvania Bar Association and others can get you in touch with resources that are legal resources, potentially at a discounted or potentially free, to assist you in setting up this planning for your future. Don't let the financial barrier get in the way of making sure that you're protected as you age. Make sure you're creating these legal documents while you have the legal capacity to sign them. As the judge mentioned, as secretary mentioned, don't wait until you need them to get them set up. These have to be set up while you still have the capacity. As soon as it's determined that you need a guardian, you can't get a POA. You can't set up a will. Those are things that now they're legal documents that you cannot legally sign. Talk to your doctors. As you heard with some of these alternatives, some can be set up through the doctors. Make sure you're identifying a healthcare decision maker. You could talk about long-term planning for healthcare decisions, organize your files and financials. One of the things we hear from guardians all the time, their family members stepping in to help. I became appointed as a guardian of my grandmother, for example. I walked in and started looking at their finances. It was all over the place. They had a shoebox with a bunch of receipts. Those are the type of examples we hear. Keep your financials, your healthcare records accessible, that if somebody needs to help you, they can get into that information. And communicate. These are tough conversations. None of us want to admit that we're mortal, that we're going to need help, but these are conversations we have to have with our loved ones to make sure that we're having it. And don't wait. How many of you, just for the people in the audience, show of hands, how many of you have a will set up, a power of attorney set up? Okay, the healthcare side does. Few people, about 50-50 in the audience. That's not surprising. I've been working for the courts for about 13 years now. About a year ago, probably a little bit less than a year ago, I still didn't have a will or a power of attorney in effect. My wife randomly came up to me and said, I scheduled an appointment with an attorney. We're getting our power of attorney. We're getting our will. So I had two thoughts run through my mind, that either my wife is really planning ahead or she's getting ready to kill me. I'm still here a year later, but this is being recorded, and if I disappear, it was probably her. So even someone that works in this area, that works for the courts, that sees the impact of people that don't have planning, that end up having to get a guardian, I still didn't have it up until a year ago. So these are things that's so easy to put down the line, to push off. We don't want to talk about it. We don't want to face it. Don't wait. If that's the biggest thing you take away from this presentation, is Don't wait to visit our website. Don't wait to visit some of the resource tables. Contact the Department of Aging. Their website is incredible for local resources that you can find to help you with these things. Reach out, start that conversation now. So on that note, as I mentioned, our website, I don't even bother putting it on our slides, Google Office of Elder Justice in the Courts. You can email us at oejc@pacourts.us. All of that's on our website as well. You can reach out to us. We have a staff of 5. We're going to get a response to you normally within 24 hours or 1 business day. We do our best. If we can't answer because we can't get involved with individual cases, we will get you in touch with the right resource that can help you in your situation. And the information for the Department of Aging on here as well, same way you can Google PA Department of Aging, or their website is a lot better than ours, so I did put that one on there. So you can go on there to find those resources, your community contacts, etc. And I have to put this on here because this program was paid for in part by a grant from the Administration for Community Living. So we want to thank them for allowing us to do these type of educational opportunities through funding through a grant. Before we open it up for Q&A, any last comments from the panel? Secretary or Judge?
Let's give the audience a chance.
That works. We've done enough talking. Thank you, everybody.
So we have both of the mics turned on in the room. If anybody here in the live audience wants to ask a question of our speakers, and then also online, if anyone wants to unmute and also ask a question.
Hi, my name is Dana Bubb. I'd like to ask a question.
Thank you.
Hi, I'm a social worker on an acute care facility, and we often have families that have not planned. And we are trying to support families that are a little bit behind in that planning process. From a social work perspective, or even through the Act 61, how can we guide families to begin that process? And what can we do from like a cognitive assessment ability to determine that people may or may not be able to make decisions if they're not taking care of their mental health?
So, yeah, take it first, Judge or Secretary.
Well, so if I understand the question correctly, it's what can you do as an employee or the workers in your acute care facility to try to help folks under Act 61?
Well, I'm getting the sense that the message is prior proper planning, right? But we have folks that have not done that. And so we have folks that we are finding to not meet the acuity from a mental health perspective. And then families are, frightened, scared, they can't take care of themselves. And there is some hesitation on how we determine, they often land on our floor when it might be time to determine guardianship. Is there a way that we can help them begin to access that emergency guardianship quickly while they're on our floor when they haven't planned?
Well, let me say this. If the family has counsel, right, they can obviously have counsel file an emergency petition, in which case, if an emergency petition is filed, you can prepare a petition in whatever time it takes and present it to the court at any time of the day. We review that petition, and then as I indicated, if we grant it, there'll be an emergency guardianship appointed, and then I have to have a hearing within 72 hours to determine whether or not the guardianship was appropriate and whether I'm going to extend the guardianship, presuming they're going to file for a subsequent plenary guardian or limited guardian. Is there, and that's if they have counsel. If not, is there a way?
Well, I was going to say, let's talk about this like as if we're in supervision, if it's okay. So, we're talking about this individual that's in your acute setting. Is the dilemma that we're worried they're going to be discharged? Is the dilemma that the family's not looking for discharge but would like to see a higher level of care? Or are you uncertain of the path?
All of the above, and also that there's not been any they haven't been deemed incompetent. There isn't any documents prepared. They don't have legal counsel. Often there is also big question marks, the decision between mental health decision-making and medical decision-making that we've kind of gone down that rabbit hole. So just a little bit of guidance, even from a professional standpoint, and what to say to families, like now is the time to kind of get prepared.
This is what we see Fridays at 4:30. This is when
Yes.
So what I would say we were going to do if you and I were planning together is, one, we need to have that individual's capacity evaluated. And that could happen in a few different ways. But first we start with the primary care physician and say, we think
Okay.
that this person has a diminished capacity and we'd like to see this person be evaluated. And then go from there and cover the medical side of it and see if this person is truly, incapacitated. If the person isn't incapacitated, that leaves you with a harder sometimes path, but the right path, because that person's going to get to make their own decisions, whether
Absolutely.
the spouse like it or not. That person still gets to make their own decision. So capacity is the key in that planning. If you're looking for legal services, you can call any of your community legal services. If you're looking specifically for services around older adults, call your area agency on aging. Don't call them in pursuit of guardianship, because that's not a matter that they could pursue guardianship on, because it's not a protective service matter. But call them to say what resources in the community, like legal resources or discharge resources, may be available to me to help this family transition or help this family work through it. In Lackawanna County, Lackawanna Pro Bono handles a lot of these cases that aren't necessarily moving forward for guardianship, but they need legal resources. The area agency on aging will help guide you to that program. So it's really your front door for services in terms of where you need to connect to. You can always call the Department of Aging. We're there. We actually have a person that still answers the phone because we are the so we will answer the phone and we will take your call. And I even have a team member here tonight that we will return your call to and see what we can do to guide you and help you. So the answers are out there, but our offices will be there to support you, because we know what it's like at Friday at 4:30 when that shoe drops.
Thank you.
If I can just add as well, these are areas where we talked about, like the Healthcare Agent and Representative Act, where there could be scenarios depending on the decision where a family member, like a spouse or an adult child, could make those immediate decisions without having to get a guardian involved, to get an emergency guardian appointed. It's an area that a lot of people, it's really underutilized in Pennsylvania, that these decisions can be made without going through court. Get that person stable. If they're having a mental health episode, get them to the point where they can make decisions again, and then pursue like a mental health advance directive or a mental health power of attorney to make sure if another episode happens, you know what facility they like, what treatment works for them, what medicine works. It's really address that problem, as the secretary mentioned, through the Area Agency on Aging, wherever those resources are, or through the Healthcare Agents and Representatives Act. But as soon as that person can make those decisions, start that discussion with the family about long-term planning.
Thank you very much. Yes, helpful, very helpful.
Thank you, Dana. We have another hand raised online. Mary, I believe it's you. You can unmute, please.
I'm unmuted. My name is Mary Dvorak. I am a retired Air Force physician, actually did residency at Geisinger, and I am a disabled veteran with Parkinson's disease, hence the tremor in my voice. I am trying to do advanced planning, and I've actually been studying this issue since I read the New Yorker article in 2017. I'm also a 3L in a remote law school program. And my concern about my advanced planning documents is, are they going to hold up in court? I don't want to demonize all lawyers and all professional guardians. That's not my intent, but there seems to be a small subset of this group who are willing to litigate against advanced directives. Several years back, there was an article on a Florida Guardianship Association website, which referred to litigating against advanced directives. And the article did not mention litigating against those directives as because there's been any misbehavior or bad conduct of the people named in those directives. So my concern is that the Pennsylvania Guardianship Bench Book says that guardians of the estate must have adequate training and experience. All of the people that I have nominated to be guardian of my estate have degrees from schools that are considered very prestigious. However, none of them are financial professionals. I'm concerned about whether my document would hold up in court if someone chooses to file for guardianship against me, because Pennsylvania law allows any person to do that. I'm concerned the judge will say, well, none of the people you've nominated are financial professionals. Let's give guardianship of your estate to a professional guardian. And frankly, I've researched some of the professional guardians in the state. There's one who seems to be getting cases, who's had a home foreclosure. There's another who works for a guardianship company who's had 2 bankruptcies. I want to know, and I want an assurance that my advanced planning documents will indeed hold up as least restrictive alternatives. And I'll open this for comment.
Well, first, thank you for your service and
Absolutely.
great question. Judge, you want to?
Yeah, let me start. And is it Mary? I didn't hear the.
Mary, yes.
Thank you for your service as well. I appreciate that. Look, let me just first say, talking about it from the context of, you know, I don't want to say my courtroom, but our courtroom. Your documents would absolutely be held or withheld. The thing, Mary, is this. The entire process and the law, as you know, you've heard us talk about, requires that we look towards alternatives to guardianship. I can't speak for any other judge because, you know, I understand how lawyers sometimes can be, but ultimately that's a decision that rests with the judge. And I can only speak for myself. If the law requires us, which it does, to look towards least restrictive alternatives, and a person has not only done that, but they've taken the time and responsibility to go ahead and plan accordingly, just as, you know, we're talking about tonight and planning for their future, then there's no way, absent a showing that somehow you didn't have capacity at the time you entered those documents, there's no way those documents would not survive a challenge. And look, that's the bottom line. And if there's any judge, I can't imagine there would be a judge. There might be lawyers that advertise and pursue that or pursued that. But I can't imagine any judge applying the law under Act 61, right? Because we're talking about Pennsylvania and Act 61, correct, Mary?
Yes, correct, sir.
Then let me just say this to you. If any trial judge overturned or voided those documents for you without a clear finding that you somehow lacked capacity at the time you entered them, they would never, that decision would never survive before the Superior Court and certainly not any higher court. So while I can't sit here and guarantee you what some other court would do, I can guarantee you what I would do. If anybody comes to me and they have advanced directives, my job is not to look at the advanced directive and decide whether or not they made a good decision for themselves. My job is to decide only whether or not they had capacity at the time, because that's the only issue that comes up. Because other than that, the law requires you maintain your autonomy. You don't even have capacity issues. So neither this judge nor any other judge should pass judgment, nor would they pass judgment on the validity of those documents showing, you know, absent of showing a clear showing that you lack capacity. Does that help?
It helps somewhat. And like I said, I'm not demonizing all judges. It sounds like you are very much on the ball. However, I see these news reports like about what was happening in the courtrooms in Nevada. And my concern is that after Act 61 was passed, The Orphans Court Rules Committee then passed a rule that sealed all findings of fact in guardianships, and our main mechanism for judicial legitimacy and judicial accountability is openness of judicial decisions. You know, I'm okay with anonymizing these decisions, but my concern is a lot can happen under the radar. And like I said, I'm not saying most judges would do this. I'm saying that there needs to be further guardrails against the sort of misconduct that happened in Nevada that led to the New Yorker article.
And good, Secretary.
No,
if you
whoever,
want-
go ahead.
I was going to say, yes, I agree with you. There always needs to be improved guardrails. And I don't think anybody at this table would say we're not in the pursuit of doing better at all times. But one thing that you have, and thank you for your service, is the one thing that you have that I don't have and others don't have is you have the DMVA, the Department of Military and Veterans Affairs, that, you know what, you reach out to them and talk to them about your concerns, and you're going to be wrapped in services, you're going to be wrapped in advocacy that will also give you another layer of protection in these instances. So I have to say about my partners in DMVA who are extremely, invested in the work that we do and support our work with older Pennsylvanians, because so many of them are veterans. They will be your support, they will be your ally, and they will help you to safeguard what you're concerned about and ease your fears. That isn't to say that the three people sitting at this table aren't going to work to continue to improve our system and put the guardrails in place that you're concerned about.
I'm going to add one thing, though. That system also isn't fail-safe. There was a case that was well publicized in Colorado about a VA fiduciary named Andrea Bouvet, who basically embezzled huge amounts from veterans. So that system, while it is excellent, I'm very pleased with the services I've received from the VA. It is also not fail-safe.
But I don't think there's any
I don't
fail-safe.
know if
yeah.
any is, right?
And last comment, and definitely want to make sure, focusing on Pennsylvania, we can move on. I know there's probably some additional questions waiting, and I know a gentleman standing here. One other area I want to highlight under Act 61 that really calls into exactly what Mary's bringing to make sure there is another safeguard there, there's another barrier there, is the required appointment of counsel. Now, if someone in Mary's situation has documents already created, she's going to have her own attorney. And if she doesn't have one that she already paid for, that is a trusted attorney that she's used in the past, now the court is going to appoint an attorney that their job is to zealously advocate for their wishes. Her wishes are already in those other documents. That's what that attorney is going to advocate for. It's not like what you see in other states where legal counsel is not required, where a lot of times that can happen. And is Pennsylvania perfect? Are there still flaws that we can work through? Absolutely. Otherwise, we wouldn't have jobs. We wouldn't have an advisory council on elder justice that's looking to improve that. And since 2019, when we had our guardianship tracking system, we've been a national leader in improving guardianship. Again, is it perfect? No, but it's an area through Act 61, through other reforms that we've had. There's so many more safeguards than there were in the past. And having that individual attorney to zealously represent anyone that might need a guardian, to make sure it's the last resort, to look at these existing documents, that is so key. And that is so instrumental in making sure someone like Mary's rights are protected and she gets her wishes honored through who she selected. Now, on top of that, again, for the general audience, things change over time. If you set up a power of attorney 20 years ago, the person you named as your power of attorney all of a sudden had a completely different lifestyle. They fallen on hard times. They've gotten arrested for embezzling money, whatever it may be. They probably don't want to be the power of attorney anymore. Maybe a guardian is the person that has to take their place. So there are extreme examples on both sides, but there's so many more safeguards than what there used to be in Pennsylvania and other states as well to protect against that. So thank you, Mary.
Thank you, Mary, and thank you for addressing her questions. We're going to take another question or two. James has been very patient waiting for the microphone from the live audience. And we did receive a number of questions in advance of tonight's program from folks who registered. You may either be online or here in the audience. We will share those with our three experts here and reach out to everybody via email. So you have those questions and you could see what those answers are. So James, thank you for your patience.
the documents that you referred to, other than having them organized ourselves and having them with our attorney and our doctor, should they be filed anywhere else?
No, no, they don't get filed. What I would advise clients is, obviously keep a copy for yourself, put it in a, fire box or a fire safe of some sort. I authorize them to provide a copy to whoever the attorney in fact was, whoever their agent was on the power of attorney or the living will and the like. And then I would keep a copy, never the original, only a copy, particularly of a last will and testament, because there should only ever be one original. But no, they don't per se get filed anywhere that I'm aware of, Secretary, that, no. So, yeah, yep. And then, of course, with your, so with your advanced directives, you want to make sure you give those to all of your medical providers. So your primary physician, if you have any specialized condition, you're seeing a specialty doctor for of some sort. And so if you have a medical team, which starts with your primary, you want to make sure each one of those has it. I don't know if the hospitals do it, but I know when I first started 30 years ago, one of the things we would tell folks or advise folks is, look, even provide a copy to your local hospital in the event, God forbid, you had an emergency and you never saw your primary physician or your specialist and you went right to the hospital. Do medical facilities, is that something, Doc?
The electronic record has made that lots easier.
Okay,
Because filed into the electronic record, assuming that the site of urgent care or acute care that the patient pursues is connected, then all of the providers.
it's right there. Well, there you go then. So, which is what you want, particularly with your advanced directive. I think most times when you have the difficulty when people are coming in for guardianships, the great majority of the time it's related to medical decisions that have to be made. I hope that helps answer your question. Thank you.
Thank you.
Thank you.
Anybody else here in the live audience?
Everyone. Thank you all so much for coming today. This is super informative. My name's Aubrey. I'm one of the second year students here. And I'm actually working on a project with my peers. And our goal is making a resource for elderly individuals, primarily in Lackawanna County, for the goal of making end of life planning more accessible, not just on like the legal front or the healthcare front or the finance front, but what to do with your belongings, what to do with your pets. As we found that all this information is kind of spread out across an array of different, websites or agencies, et cetera. So I kind of had a similar question to what was already asked before. In working with elderly over the past year on this project, there's been an overarching theme of like this big fear of talking about end of life planning, like was mentioned before, like confronting your mortality. So a lot of these individuals are hesitant to even do the planning, which we've already said was kind of the biggest factor in having guardianship take place is lack of planning. So for those individuals who have not planned and find themselves incapacitated and may be up for guardianship, who don't have any loved ones or don't have any friends who could fill that position, what happens to them and what could physicians or clinicians do to advocate for those individuals?
Well, thank you. Thank you for what you and your peers are doing. Okay. I'm excited about that. I mean, I think that's an incredible project. And the second piece to that is, a chance for me to have a shameless plug. And that is, if you look at the Department of Aging's website, we have created the Pennsylvania Caregiver Toolkit. It's part of our second initiative. Have you looked at the toolkit?
Oh yeah, we'll be including information from that in our booklet.
So you saw all our pieces about it planning. Oh, wonderful. Good. So you've looked at that resource. So, but I do love that you're assembling the resource on a local level. And looking locally and for the problem that you described is incredibly important. And pulling those resources like Lackawanna Pro Bono, like the resources you saw about planning in the care kit, all of them together in one spot for someone who is, whose planning is great. But we have so many individuals that have no one. And those are the ones that we really don't have a fail-safe system for. And area agencies on aging get involved, and sometimes judges have to become involved, and we have to see the courts appoint a guardian because there's no one else to pick up that individual. Uh, Oftentimes they become impoverished or indigent, and that's a sad situation as well. But I think in those situations, that's where the social services net catches people. The area agencies on aging catches people. And it's a hard it's a hard day for everyone. But I otherwise I don't think there's any other safety nets in place, that can. um,
Yeah. The physician.
Oh, right. Yeah. Okay. So Bill's been helping me out for years. Another proud member of the Pennsylvania Council on Aging too. Again, assembling all those resources in one place, that's a huge project. Thank you for doing it. If we can be of help with the department, we'll offer you any kind of resources we can, share with you anything we can do, and bring in other state units and departments too to support you in that project.
I already offered you because.
I was planning on reaching out to
Yeah,
you anyway. I
that's
just snagged you in
Aubrey.
person.
Okay, all right.
She actually reached out to me probably Aubrey, 6, 7 months ago. And obviously, when they were talking about what the idea was, the two folks that I literally mentioned, Aubrey, are right here. So we'll introduce you formally, but what they're doing is really amazing to try to put forth that resource guide. So we'll connect
Great work.
and because I think it'll be
Yeah,
very helpful.
absolutely.
Yeah. Your second year now?
Yes,
Second.
thank you.
Thank
Thank
you.
you so much.
Thanks, Aubrey.
Thank you.
Okay, thank you, Aubrey. All right, we will conclude tonight's program, but I would like to extend our deepest gratitude to
Thank you.
Secretary Kavulich, Judge Ruggiero, and Mr. Hinkle for joining us this evening, taking time out of your very busy schedules, making the trek across 81 to Scranton. Appreciate that. And we hope to host you here again in the future.
Appreciate it.
Thank
you.
you.
Thank you.
Wonderful.